I'm Finnis and I head up the family team here at Girlings. I have been qualified as a solicitor for over 20 years now, specialising exclusively in family law. I'm also a resolution accredited specialist. This means I've been recognised as being a specialist in the area of financial settlement following divorce or separation, and also children work. This means my clients can have confidence that I've got experience and expertise. Today I'm going to be talking about how we deal with finances when it comes to divorce or separation. The first thing we need to think about is what assets there are, in whose name they are, and what's the value of those assets. Quite often I'm talking about voluntary disclosure, which is the way in which we share information. There is a duty that both parties need to give financial disclosure, but they may not want to. So if they're not going to give that disclosure, we may need to go to court. Voluntary financial disclosure at an earlier stage enables us to hopefully reach a financial agreement and save some legal costs. I'm often asked, should everything be divided 50-50? 50-50 is just the starting point. It doesn't necessarily mean that that's appropriate in every single case, particularly if it's been a short marriage. Financial needs of the parties is going to be one of those factors, along with everything else. A key issue is often housing needs, where a party wants to live. So I'm often asking clients to go away and get property particulars and independent mortgage advice. Children are the absolute paramount consideration. And as a resolution accredited specialist, that's something that I keep at the forefront of my mind. When I sit down with my clients and talk about financial settlement, I'm often talking about three distinct areas. The first tends to be capital. What's the value of property? Maybe there's savings, a business, a second property. What's the value of that capital and how should it be divided? Secondly, I'm talking about pensions. Are there pensions? What's the value of the pensions? And how should those pensions be divided? It may be that there's been contributions towards the pension before the marriage, and that's a factor we need to think about. The third area is maintenance. Now there's two types of maintenance, there's child maintenance and there's also spousal maintenance. Child maintenance, we might be talking about how much should be paid or how much should be received. In terms of spousal maintenance, that's more complicated. Spousal maintenance is money that's paid in addition to child maintenance to a husband or a wife, and for that there's no specific formula. We're looking at each party's affordability and needs. Often clients talk to me about achieving a clean break. Now a clean break is where there's no continuing financial obligations between the parties once they divorced. Now, spousal maintenance may be appropriate, perhaps for a short term, to help a party get back on their feet. In amongst all of those three areas, I'm also trying to remember what the client's particular wishes are. They might be really attached to a house or a piece of jewellery or whatever, and it's a case of me trying to work all of those factors out and try and achieve a settlement that's fair for them. I think here at Girlings we're experienced, we're established, but we're also human. We've got a strong reputation. And I think in the family department specifically, the team that we have, we work together closely, and all of us are dedicated family solicitors who have got experience and knowledge, and we can understand what clients are going through, recognising that everybody's individual. If you have any questions about financial settlement following your divorce or separation, then don't hesitate to pick up the phone, give us a call and come in and see me.